today. This session is going to cover the Employment Rights Act as it now is, and what it means for you guys in practice. I'm going to focus on legal risk, exposure as an employer, and how to prevent and prepare to avoid later disputes. So rather than a lecture, if you like, this is a practical employer-focused briefing rather than a technical lecture, if you like. So I know that people are still arriving, but I will crack on.
No, it's all right, don't worry. Yeah. Okay.
Saul, I can hear you.
Okay, sorry.
So, what does it mean? The Employment Rights Act actually presents the most significant change to employment law in decades. We've been anticipating this change, and well, we've been wondering what it's going to mean for you for some time. The Act was actually introduced. Oh, sorry, can everyone hear me? I'm just concerned now. Someone said they're having trouble. Everyone hear me? Yeah, okay, I'll carry on. So the Act was introduced originally on the 10th of October 2024. I need to stop getting distracted, don't I? And got royal assent, i.e. became an act on the 18th of December 2025. It's anticipated, or it will be, the early provisions will be introduced in April of this year. Those early provisions we'll go on to in some detail later, but these are the day one rights that are going to come into effect. The major rights that, again, we'll cover shortly will be introduced, phased introduction throughout 2026, 2027. Some of them require a secondary legislation implemented in order to pass, but I won't bore you with that stuff at the moment. We can have another webinar to go through that. Unfair dismissal and removal of cap is anticipated to come into effect on the 1st of January 2027. So those are all your dates in the background, but what this basically means is that employee protections have increased, tribunal exposure and additional enforcement. For employers, this means that informal practices that may have worked in the past now carry a greater risk. I'm sure for those of you who were on the previous webinar I did on this, we had a discussion about what it meant for you in relation to probationary periods, etc. So early preparation is key in this case to controlling cost and disruption. You will see in one of the later slides, I've sort of put together a little table, if you like, of a summary of when we need to get things in place. So we can go through that in detail later. So let me just get rid of this. So from an employer's perspective, these reforms create several major pressures for you. And as you can see from the slide, it requires proactive changes from you as employer in relation to dismissal and grievance risks and policies. So the likelihood of a grievance being raised will be greater. Your flexibility in relation to the workforce will reduce. That's due to various points, particularly 0-hour contracts and variable arrangements. Unfortunately, it may also result in administrative and payroll costs rising. In addition to this, there is a stronger trade union engagement. This will allow for additional collective responsibilities and increased regulatory scrutiny. that is by way of the Fair Work Agency, which we'll get on to later. So my takeaway from the Act is that reactive compliance is going to cost you a lot more than if you plan it. So that's where we as a business will assist you. So we will look to your contracts, we will consider your workforce planning with you. It's critical that you have your policies and procedures in place. There's also an issue in relation to line management, and I know a lot of you have these issues where, you know, managers are managers to manage what they know. They're not managers managing employment law. So again, there's an element, isn't there, of managing and training your line managers to ensure that they're capable of dealing with the issues as they arise. So the key employer impacts, as I've just said in the previous slide, are administrative and payroll costs will increase. We need to have planned compliance. So a lot of you will have 0-hour contract. Guaranteed hours reform directly affects you and your 0 hours and variable contracts. So we need to make sure that if this is something you work with, that we revisit it, and accurate records and workforce data are critical to how you move forward. So, guaranteed hours and zero contract reform. These are difficult because they are essential in some industries that require flexibility in demand-led scheduling. So if you have a demand-led business, you know, you need people as and when. It's always been the case that you have relied on 0-hour contracts. With this Act, you must offer guaranteed hours where regular working patterns develop. And again, this takes some work to look at and implement. And it also goes back to the fact that you're going to have records of the hours that have been worked so that you can look at the preferred payment period, if you like, and make a calculation based on what they've worked over X amount of time. That used to be 12 weeks. It's then gone back to 12 months, but you'll need to look at it realistically, you know, and practically from your business point of view. But it is going to make your admin function considerably greater. So you will need to take action now to review the 0-hour contracts, model the cost impact. So have a look at what the cost implications are of the 0-hour contracts and make sure that you have the scheduling and record keeping systems, so timekeeping. The action you need to take, as I say, is review 0-hour contracts and variables. I've seen a quick question. I get so distracted. I need to focus. I've seen a question come in about what happens if the employee actually wants a 0-hour contract, in which case you can, I guess, guarantee some hours. So it's all about looking at what you are going to use that employee for. Why would they want a 0-hour contract unless they have another job? Or I think most of the times it's sort of flexible working, isn't it? It's student work in the bar. I think you would still have to guarantee some hours in the contract itself. I don't think that you would be able to mutually agree to a 0-hour if the Act is specifically prohibiting it. Yeah. And as I'm sure a lot of you will be aware, and again, I touched on this on my previous webinar, fire and rehire. This has been under scrutiny for some time. And a statutory code of practice came into force in July 2024. And under the Act, dismissal becomes automatically unfair where an employee is dismissed for refusing contract changes and the employer seeks to re-engage them on new terms. This has now introduced the automatically unfair dismissal, where an employer seeks to vary a contract and the employee does not agree to that variation. So it goes back to there has to be a mutual agreement. You can't do it unilaterally. And is seeking to employ another or re-engage the employee under a varied contract to carry out substantially the same duties as the employee carried out before being dismissed. So if, I suppose, the scenario that we have is you want to change a contractual pattern of work in working hours, let's say, and they refuse that, and as you all know, you need to be careful on that, because if they refuse for any protected characteristics, we need to consider it separately. But where we could historically have said, well, it's a pressing business need, and therefore if you do not accept this, we are going to terminate your employment and re-engage you on new terms, and somebody else is going to do that because they've agreed, you're risking the automatic unfair dismissal provision that this has now set in stone, if you like. So this applies to fire and rehire and fire and replace. So that's something key to note as employers. It's the fire and replace scenario as well. So what is the significant change here? Fire and rehire will now be automatically unfair in almost every circumstance. I mean, it was always a good way of trying to implement significant fundamental changes that were required for business needs, where the employee absolutely refused. But we can't do that anymore. There will be a higher tribunal scrutiny of consultation, alternatives, any evidence that is necessary to establish that this was a necessary change. So this is going to make contract changes riskier, significantly riskier, because obviously it has to be tested, because we don't know as yet whether, how tribunals are going to approach it. But I would imagine that they will be quite keen for employers to show that this is not a backdoor way of dismissal. My advice is always take advice before any dismissal-led changes on the contract are going to take effect. So if you are planning fundamental changes, so I always say fundamental is where you need to mutually agree. You can't unilaterally change fundamental. If you think of fundamental changes to a contract as being those that, one, may be dismissal-led, and two, are fundamental to the employee's pocket, for want of a better word, that's what they regard as fundamental, and that's what a tribunal would see as fundamental. So, if it's a minor change, you're not going to fall foul of automatic unfair, are you? Because the fire and rehire is not going to come into effect. So it's something to be mindful of. And if you are planning restructure changes, contract changes, I would suggest when we get to the end, you'll see that you do so sooner rather than later. Can we avoid it? Because we all, you know, it's something that you do need to do on occasions. The defence is very narrow. You must, as it says on the slide, you have to be able to satisfy the two conditions: that the reason for the proposed variation was to eliminate, prevent, significantly reduce, or mitigate the effect of financial difficulties, which at the time were affecting the employer business. So that, I suppose, that is something that you would look at as by way of a restructure, but you would need to satisfy that if you were looking at changing someone's T's and C's. And the bar goes a little bit higher because you also, in all the circumstances, you could not have reasonably avoided the need to make the variation. So you've got to show genuine financial distress, threatening business viability, and that the contractual change could not reasonably have been avoided. To any person, that is a pretty high evidential bar to be satisfied. It then goes back to, even if you manage to jump over 1 and 2, you're then going to have to ensure that the tribunal is assessing it based on the reasonableness in any event. So we all know the Birchall test, that everything has to be reasonable. So in essence, you've got 3 points that you would need to overcome to avoid the automatic unfair dismissal. As you know, automatic unfair dismissal carries with it a significant risk at tribunal and can be extremely costly. So it's essential that we get everything in place beforehand to ensure that we're compliant. How can we do that? It's difficult to say, isn't it? Because these instances occur because something immediate has happened that needs addressing, whereas the evidential bar is such that it doesn't allow for almost knee-jerk provisions to be put in place. So we do need to make sure that whenever you're considering these elements, that there is a business rationale. And for those of you who I advise on redundancy, etc., and restructures, I love a good business rationale. That can take you quite far when you're trying to justify your position. So, qualifying service changes. Now, this was going to give everyone a little bit of a headache to begin with. I think we all panicked because it started off as a day one right, didn't it? And it was, how are we going to get past that? Aside from your protected characteristics, because as you're all aware, you know, there are elements and protections in place for individuals that will attract day one rights to claim unfair dismissal in any event. This is still one of the most radical changes to unfair dismissal law in over 50 years. I remember when it was a 1-year qualifying, and that was okay, but it still left employers with quite significant issues. To reduce it to 1 day was an absolute nightmare. So we've now seen since, well, we haven't because we'd left it at 2 years, but the qualifying period is now reduced to 6 months. This is one of the early provision changes. This is being set to come into place on the 1st of January 2027. But the way this act has been moving around organically, we're looking at that date at present. So, key changes. Qualifying period reduced to 6 months. Compensation cap is removed. And there's easy access to tribunals for new starters, obviously because we've got the 6 month limit. This is a really high litigation risk, and as it says at the bottom, the action you need to take, I would say significantly, is look at your probationary period. Probationary periods used to be there to allow you to manage somebody during the initial stages of employment, and because it was a 2-year qualifying period, or prior to that 1 year, probation was there to reduce the notice period, is what I used to use it for. So during your probation period, you will, we reserve the right to give you a week's notice. Now, your probation period needs to be a significant part of the contract. So it's no longer just a thing that you put in place to manage somebody for 6 months, and then their notice period increases. It's now going to be a significant instrument in your management. Therefore, you need to put a probation period in place and make sure that the probation review is carried out. There's no point in having a probation period if it just passes and nobody actually meets with the employee to determine whether they're fit for role. Again, at the beginning, you'll recall that I said we need to look at managers. Managers are managing what they know how to manage. You need to train managers on early performance management. It stands to reason, doesn't it? You can't expect managers just to know what to do. And because of the risk that comes with this, you need to make sure that they have the correct training. At least then you have an argument. Let's leave it at that. You have an argument to say, well, we did everything we could because the manager carried out the probation review. I've also put as an action, document decisions thoroughly from day one. And again, for those of you who know me will know that I'm quite keen on paper trails and looking at development and management of staff from day one anyway. So there is no point in your manager coming back to you after 6 months to say, actually, Joe Bloggs is rubbish. He's been rubbish since day one. I've done absolutely nothing about it. Got no records, but I want to sack him. It's not going to wash anymore, is it? Because they will be able to make a claim. It doesn't take you away from dismissing an employee following the correct procedure. Just because it's reduced to 6 months, think of your 6 months as we would the 2 years now. If you need to dismiss someone, you can still do so, but you have to follow process because they have the right to make that claim earlier. So basically, all it is you've shifted what you would do after 2 years to what you do at 6 months. Yeah, I've put here settlement values are likely to rise. That makes sense, doesn't it? Because there's likely to be a bigger loss flowing from your breach if you dismiss without process. That goes back to also having your disciplinary process clearly set out. And anyone who has and I'm sure quite a number of you have, anyone who has within their handbook that your disciplinary process doesn't apply for employees with less than 2 years service, obviously we'll need to amend those for you. So the government has introduced amendments to this whole act has come from the Employment Rights Act 1996. So it's done it by sort of amending. It's not a standalone act, it's standalone provisions to the act. If any of you are bored, insomniacs, whatever, have a read of it. It will certainly do the trick. But it's not a standalone, so everything is incorporated, so we still have the Employment Rights Act provisions for other areas that are still valid. So the initial period of employment is between 3 and 9 months. So we need to look at, what do you put your probationary period at? Well, they can claim automatic unfair dismissal from 6 months, but that doesn't stop you performance managing or having a probation period that goes past the 6 months, does it? You know, you just have to make sure you do it correctly. I would not just assume that the initial period of employment and the 6-month qualifying means you've got a risk-free dismissal window. I would say that because of the way the act has come in and because of the potential risk at tribunal, that you put your probationary period in place, and I can see that some questions have come in about that, which we'll look at the end. Put your probationary period in place. Even if it's 6 months, make sure you're reviewing 3 months, 6 months. You can put a 9-month in. So you can still manage the employee as you see fit, but they can make a claim earlier. That's it in a nutshell, isn't it? Their claim can start at 6 months. I mean, this seems quite obvious. Withdrawing an offer remains the same. They don't apply, so they can't claim unfair dismissal for an offer being withdrawn unless it's been withdrawn on the basis of a protected characteristic and the additional points that I've put below. So not really much of an impact on an offer withdrawal, but you know, there have been various points where we've been asked, can I withdraw this offer now because I've found out that the individual is pregnant? You know, though that's a different scenario to I'm withdrawing the offer because you didn't pass the DBS, your reference is rubbish. As long as, again, you have your documented policies and specific offer letter that says you reserve the right to withdraw. So I just thought I'd touch on that. Not significant for a lot of you, but it is something to be mindful of. Okay, so day one rights. At the beginning, I mentioned that there's early provisions that are going to come into place in April, and this is one of them. So it's going to be payable from day one of employment, and the lower earnings threshold has been removed. What's the impact? Increased payroll cost and obviously admin. The administrative burden is bound to go up. There's also, and this is the bit that I think will possibly, let's say possibly rather than probably, let's be kind, possibly have a significant impact is the short-term absence abuse. At the moment, people don't get paid for the first 3 days of absence. So it's a deterrent to a degree. Now that you're going to be paid from day one, my view is that your absence policies and procedures need to be tight. Short-term absence needs to be monitored, be it by online monitoring if you have a software system. Let's look for patterns. Your Monday, Friday-itis is always a good one. Potential Bradford factor you could put in place. Basically, you need to be managing it because there could be a knock-on effect. As you know, sometimes if you offer company sick pay, for instance, I've come across cases where employees have treated the company sick pay as just an additional few weeks. You don't want that to apply to your short term. And short-term absence costs businesses far more than long term, because you have, at least with long term, you can plan, you can cost, whereas short term, you have to potentially, well, for care homes, for instance, you often have to have agency staff in to cover, which is double the cost. So you really do need to look at and review your absence management policies and procedures, particularly short term. And that needs to be linked then, doesn't it, to your disciplinary capability policies. We need to make sure that we're considering whether an individual is actually sick or whether they're just off. So we need to review all those policies to make sure you're not going to fall foul. As I said at the beginning, it's better to be proactive rather than reactive here. That comes in April, so we need to be looking at those as soon as possible. Flexible working changes are already in place. Day one rights, again, these are the early provisions that are being put through. So day one rights, what's this going to mean? Because I know that you all know what's happening. What does this mean to you as a business? You're going to have more requests to manage, aren't you? Flexible working has been one of those where it started out as a very tight application that only a few people could qualify for. Now it seems, well, it is something that it's very difficult for an employer to refuse. So you're going to have more training, and again, I'm going back to these poor managers that are going to have to be trained as a first point of contact in relation to any applications for flexible working. They will know how their department operates. They will know whether it can be accommodated, but it needs to be consistent. It's going to be quite difficult to refuse. The protections are much stronger now, and also we need to make sure that it's consistent. Consistency is key. So if you're not consistent and you give Joe Bloggs flexible working but Mary can't have it, you've got a discrimination risk there immediately, haven't you? So again, let's look at manager training. Get your standardized frameworks in place. So have it clear that you can accommodate flexible working in these circumstances. If it's an area where it cannot be accommodated at all, Do you remember me? I spoke about the business rationale and how much I like them. There has to be a business rationale to say, these are the reasons why we can't accommodate, but they will be few and far between. Ensure the role-based flexibility assessments. That's absolutely key, isn't it? So you look at the role and ensure that the role is flexible. What is a lawful refusal? Again, all these things need to be addressed, and the managers need to be trained. Again, I've seen a couple of questions coming in on what is a lawful refusal, etc. There is a sort of point guide to the reasons why you can refuse. That will be and can be picked up by your advisor, because it's something that is already in place. This is just expanding on the protections that are in place now. Harassment, equality, and NDAs. So I think a lot of you have already seen our webinar on, I think it was the sexual harassment, because there's now a positive duty to prevent harassment, not just respond to it. I'm not sure how you can positively prevent harassment if you're not aware of harassment. All you can do is ensure that you have your paper trail, your policies, grievance policy, so that employees have grounds on which they know what to do if they feel harassed. You can't actively stop it, can you? Because you don't know what Fred and Phil are doing in the workshop. So you can't prevent to that extent, but you can prevent to the extent that you have the policy in place, that everyone is aware that there's a grievance policy. So any harassment, potential harassment, is reportable, and strengthen your reporting and investigation processes. I would also suggest, as I've put on the action point, that regular manager training, these poor managers, regular manager training is put in place to ensure that people recognise that what harassment is. Because in all fairness, not everybody knows if they're harassing somebody. It says, cultural issues. Certain people have, certain banter, let's say, which isn't banter, really. It's harassment. But some people won't recognise it as such. So proactively, let's look at training to make sure that people are aware of what harassment entails. Same as bullying. Bullying is another one where a lot of people don't appreciate the significance of what it is. So regular training is absolutely key so that you don't fall foul. On your NDAs are non-disclosure agreements. Not only non-disclosure agreements, though, but non-disclosure provisions within agreements. So you'll probably have dealt with settlement agreements. NDAs can't prevent disclosure of discrimination or harassment, which is I would say a bit of a nightmare. But they were part of a standardized approach. If you do an NDA, the NDA is particularly relevant to cover the ones that are going to cost more or have more of an impact on the business. So those were particularly in relation to protected characteristics, discrimination or harassment. So that's no longer applicable. We will update any templates and agreements that you have that you may wish to tweak in order to be compliant. And we will update all our precedent documents so that that's the case. Another change, this is a change that we're looking at, I think, end 2026, 2027. Trade unions gain expanded access rights and stronger protections. Collective bargaining is going to be easier, and this is a simplistic approach to the trade union and collective overview. If anyone has any specific questions, or if you're part of a collective agreement, then we can have a look at that for you, because we will need to basically check that you are compliant and it's consistent. There are going to be increased union presence potentially. And with that, you know, you've got an increased union presence, you're going to have an increased risk of legality, of legal risk, strike action, industrial disputes, etc. Even non-unionised employers may face increased collective engagement. So you might not have a collective agreement in place as of now. And as you know, your contract of employment has to have a provision in it that says you do or you don't have a collective agreement in place. Those of you that don't, because the ability to unionize and the amount of individuals required for unionization has basically reduced so that they have a stronger protection, it's important that you address it and have it in the background in any event. As an alternative, years ago, when they introduced the initial stages of fair working provisions, there was talk of a workplace agreements. Workplace agreements are good because you're sort of half a step towards the unionization without it being unionized, if that makes sense. So you have a table of individuals reflective of the industry that will collectively discuss issues that a union would ordinarily do, so pay, terms and conditions of employment, etc. So if you have a collective agreement, I think the takeaway point is give me a shout and we'll have a look. If you don't, I would suggest that you look potentially at a workforce agreement and prepare for increased consultation obligations. And another action is that train leadership on lawful engagement. I apologise in advance to all you managers and leadership for the amount of training that I'm proposing that you have. So, as I say, trade union is a minefield. So if you could get in touch with me separately on that, that would be great. Redundancy and restructuring. What's changing? Enhanced consultation requirements and higher protective awards for failure. So consultation requirements are being enhanced. So your consultation and restructure is going to take longer. You are going to face greater financial penalties if you get it wrong. will be removed. So the tribunal cap will be removed. So there is a significant risk if you get it wrong. What I would suggest, and I don't usually like having a redundancy policy per se, but what I would suggest is that this is considered separately, so that you can, well, basically so that you're transparent in what you are proposing to do. Time isn't going to allow me to run through the exact consultation requirements that are needed, but I will put something together as a separate document, if you like, because it's going to be something that I'm seeing a lot more redundancies coming through now. So it is something that we need to get in place and be mindful of. For those of you who carry out meaningful consultation and have the documentation in place anyway, you will be fine. Again, make sure that you follow the process and you have your business rationale in place moving forward. The Fair Work Agency, that is, I think, ready to be introduced in April. So we need to, I can double check that, but it's going to have extensive enforcement powers. So if you get something wrong and the Fair Work Agency arrives, it can issue underpayment notices going back 6 years, impose penalties of up to 200% of underpayments, and assist. They won't bring, but they will assist in tribunal proceedings. This is proactive enforcement, isn't it? So it ties in with proactive planning from your perspective. It's going to be less reliance on complaints alone. And where we could initially deal with something by way of a grievance, the Fair Work Agency has increased regulatory exposure to this extent. How can you avoid it? By planning, by having things in place to show that you are compliant in relation to everything that we've discussed. Have an audit trail, have a document trail, update your policies and procedures, and have relevant personnel files with documents in them. So have the relevant documents contained within the personnel file so that, I've said there, record tribunal ready, so that you're tribunal ready, even if you don't go to tribunal, if that makes sense. Make sure that you seek legal advice if you're entertaining any dismissal-led policy and planning. So I've said policy and planning because dismissal-led can also be redundancies. Make sure that you have everything in place before you do it or take any action. In that case, you are compliant and the Fair Work Agency won't have any regulatory impact on you. So what does this mean for you? I've highlighted the immediate priorities. And again, for those of you who are clients, I would suggest you speak to your advisor. We will be putting things in place to ensure that at each stage of the process you are compliant. So audit contract and policies, identify high-risk roles, train managers on everything by the sounds of it, budget for increased employment costs, and that also means budget and plan for increased recruitment provisions. And when I say that, I mean because you need to get the right person in bearing in mind we've got the 6 months now. So it's no longer the case of get somebody in and you have a long period of time to assess them. So your recruitment provisions may be increased. And always engage legal prior to anything occurring, not after. Processes are one of the key elements that you will fail at tribunal. In a lot of cases, tribunal can't insert their own decision for yours, but they can find that your decision was wrong because you failed to do it correctly. So, for instance, if you go through a redundancy and the redundancy is fair, however, you fail to follow the process, they won't change the decision as such, but the dismissal will be unfair on a procedural point. So whilst it could be a redundancy, you failed on the process. So make sure any dispute, any contentious dismissal-led are discussed with legal first. So enhance your recruitment procedures and make sure your procedures for probationary period is in place. You may want a policy for your probationary period. This is what happens during the probationary period. And this is how we are going to, sorry, I got distracted again. This is how we are going to manage you during that time. So again, it's all about policies and procedures. What are the key takeaways from this? Well, it's just a logistical nightmare for some of you, isn't it? It's going to raise the cost of getting employment decisions wrong. It is going to reward good management, documentation and consistency. And if you adapt to this, you will be successful. You won't fall foul of the provisions because there's nothing damning in there. It's just an act that needs you to be proactive. So if you manage well as an employer, it shouldn't make any difference to how you continue with your employees. If you are doing informal meetings, if you rush, if you sack people on the spot without having anything in the background, you're going to face litigation and higher costs to the business. And actually, it's not worth it. For want of getting a few things in place now, we can move it forward. So prepared employers will adapt, unprepared employers will litigate. I quite like that. So here's your takeaway. This is what I think we need to be looking at. So this goes into sections on, let's look at how we get everything in place in a reasonable timescale, bearing in mind you have a business to run. So we need now to be looking at your policies, procedures, etc., in order to be ready. April day one rights, let's look at the SSP, make sure your policies are up to date for that. And moving forward, your major rights are going to be phased in 2026, 2027. So you've got contract and schedule changes. Unfair dismissal, 6-month qualifying period, January 2027. So we should now be starting effectively to get your policies and everything in place so that you're up to speed come, I would suggest, by September this year. Happy to take any questions on how these will affect you. However, you do have your own lawyer who will be happy to pick anything up from you. I understand that Saul is going to send out or make available a recording of the presentation. I will pick up the questions and come back to those shortly, but I'm mindful that I've wittered on for an hour and you probably all have better things to do. But I will have a look now. Let me see if I can find any of the questions. Saul might have to help me here. Yeah.
Sharon, I'm just going to post the questions at the bottom of the chat, and then we'll just try and address as many as possible if that's okay. So you don't have to search.
Yeah, I was going to say, because there's
Yeah.
quite a lot, isn't there? So
Yeah,
I'm
there's quite a lot.
thinking, what I may do, I'm just conscious that it's 11 o'clock now, isn't it?
I've made a note of all the questions, so I can pass those on if they're clients and stuff, but we can pass that to the lawyers if you want to.
Yeah, thanks to David Wilson for the Fair Work Agency. It is April 2026. Some of the questions here are going to need me to have a proper read through. I can assure you that anyone's put a question in, we will get back to you, either myself or the lawyer that acts on your behalf. If you are not a client and you want some assistance, if you could just send me an email and I will get back to you. And thank you everyone for joining.